All right, our apologies for that, everyone, but hopefully we are set. Welcome to today's program titled Another Day, Another Immigration Executive Order. Now federal contractors are targeted. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down as it will not be reread and is required for CLE credit. This session is being recorded. Copies of the webinar recording and materials, along with the CLE attendance form, will be distributed to attendees in the days following the webinar. At this time, I would like to turn it over to Masa Alaskari. Masa, please go ahead.
Thank you so much. Hi, everyone. Thank you all for joining on this Friday morning or afternoon, depending on where you are. We know that a lot is changing constantly, and we thought that it was important to take a little bit of time today to kind of talk through the latest executive order that was issued that is likely going to impact more organizations than you may think upon reading the title alone. I'm joined by my colleagues here at Seyfarth, and I will give them an opportunity to introduce themselves in a minute. My name is Masa Alaskari. I'm an immigration senior counsel based out of our LA office here in California. And I've been practicing immigration for 2 decades now, both on the benefits side and the compliance side. And I have to say the last 3 years have definitely been some of the most interesting ones and challenging ones. And we also have Michael, who's an associate in our Chicago office. I'm going to turn over to Michael so he can introduce himself.
Hi, thanks, Masa. I'm Mike Childers. I'm an associate in Seyfarth's People Analytics Group. I focus on assisting federal contractors with OFCCP compliance and investigation, as well as kind of all things pay equity, inclusion, diversity, and data and analytics. So I'm here to give you your OFCCP flavor on the new executive order.
Thanks, Mike. And we also have Dawn Lurie from our DC office on the panel.
Thanks, Masa. So I'm Dawn Lurie. My practice is focused entirely on immigration compliance. So that deals in the world of Form I-9s, E-Verify, H-1B investigations, if it touches with compliance, then I deal with it. It's been an exciting and interesting past few years under this administration, and I've been fortunate enough to be able to support many of you on the phone today, as well as many of our clients. So again, compliance is me. Go ahead.
Thanks, Dawn. And we also have Angelo Paparelli, who's a partner also in the downtown LA office here in California. Angelo?
Hello, everyone. I am the elder statesman, so to speak, snow on the roof, fire in the fireplace, very passionate about immigration, and I'm involved in compliance, defense of employers in investigations, complex immigration benefits questions, and litigation.
Thanks, Angelo. So, to start off, we just wanted to set the stage for everybody. Most of you who are involved either on the benefit side and sponsoring individuals within your organization in different visa categories, or on the compliance side, dealing with any sort of I-9 investigations, audits, or just internally creating programs and protocols, you've really seen a shift in the overall immigration landscape over the last few years under the current administration, with trends that have impacted benefit side and just day-to-day compliance issues, from seeing increased number of requests for evidence that challenge and target H-1B programs and L-1 visa programs, from questions about what qualifies as a specialty occupation. It's really taking a lot longer and a lot more effort in sponsoring individuals. We've also seen litigation kind of being the savior in a lot of this. We've seen an uptick in litigation within immigration on the business immigration side, where we normally would not have thought of litigation as a go-to. It's become more and more common, and those of us who swore we would never litigate have learned a lot more about litigation than we ever wanted to on the immigration benefits side. And then more recently, we've had executive order after executive order and proclamation, really changing how we think, how we understand, how we can move our personnel around with COVID-19 in particular, pushing this administration to issue a number of travel restrictions impacting our ability to really mobilize our workforce and get our top talent where we need them. So all of that has everybody asking a lot of questions about what it means, how it impacts our ability to sponsor people, how it impacts our ability to have our contracts updated, changes, et cetera. So we know there's a lot of questions, and when we do—
Masa,
yes.
Before you move on, I just want to mention that next Thursday we're going to have another pop-up webinar, and that will talk about the national interest exemptions under the presidential entry bans. And so stay tuned, audience, and you might find that of interest as well.
Exactly. So there's a lot going on, and these 1-hour sessions, I think we're trying to hone in on what the questions are that we're hearing most from our clients and the people that we work with. But let's get into this latest executive order that really touches on federal contractors, and not just the direct contractors, but the subcontractors as well. Dawn, can you kind of walk us through what this executive order outlines?
Yeah, absolutely. I think it's easy if we chunk it out. First of all, the executive order came out a little more than 10 days ago on the 3rd. President Trump signed the order, and we can look at it as two big chunks. First one is Section 2. Basically, that requires federal agencies to take a look at who they're hiring and whether or not they're using foreign temporary workers. Generally, it's focused on H-1B workers. So that's the federal agency should take a look at who they're hiring. It also requires a review of offshoring practices by federal contractors as well as the subcontractors of those federal contractors. In addition, it's also directing that the Department of State, the Department of Homeland Security, Department of Labor, and Department of Homeland Security take action to enforce the H-1B regulations. And what they really want to know is whether or not U.S. workers are being impacted by the hiring of the foreign workers. So let's go to the next slide, and we'll talk about the federal contractors versus thank you. First of all, right now we don't know who the specific contractors that are going to be affected by this rule are. So when we talk about federal contractors, and of course we lean heavily on our government contract group here at Seyfarth, but when we talk about that, we want to break down the executive order, right? We want to know who's the federal contractor. So once all the specifics come out, we're going to want to determine who is that federal contractor? What is the specifics in the contract? Will it have a minimum contract value in order to be affected by this order, right? Will there be specifics in terms of the length of time? So those are the types of things that we need to look at for the federal contractors themselves. When we talk about the federal agencies, we're talking about the agencies, and there's many of them. We're talking about the agencies themselves that are doing business with companies. So this order, just to kind of take a step back, it was signed, there was a whole ceremony that really highlighted the issues that we saw at the TVA. There were, if anyone had an opportunity to look at the remarks or to look at the press conference, basically President Trump was saying to the American public, look, we're going to make sure that there are no U.S. Workers being displaced as a result of hiring of H-1B workers. We don't know all the specifics yet. There were some grumblings as to whether or not everything was done correctly at the TVA.
Dawn,
Sure.
Before you go on, for those of us
Sure.
who may have not read up on the TVA, what is it, what happened, and what led to the kind of the TVA employee actually being there at the ceremony itself?
Right. Well, I heard that President Trump had worked with one of the TVA employees before, so I'm not sure of all the specifics behind that. But basically, there were U.S. workers that had received notice that their jobs were going to be replaced by H-1B workers. So,
and Dawn, the TVA, just for clarification, is the Tennessee Valley Authority, and it deals with developing power through the Tennessee Valley.
Yeah.
In a quasi-governmental capacity. Exactly.
And I think it could have been any agency. This one, made a big splash, right? It could have been the Department of Homeland Security, right? But for whatever reason, there were issues here, and they made for an interesting headline. So the potential was for what we've heard was almost 200 U.S. workers could have lost their jobs. So we understand that there were already, that TVA was already working with companies that were, that had their employees on site, but then they also were using other companies. They were using staffing companies that were then bringing their employees onto TVA sites. We don't know the specifics of that yet, so I hesitate to give out misinformation, but there are allegations that the rules were not followed. And we'll talk a little bit about labor condition applications in a while, but the allegations are that there were not the filings that were supposed to be done actually done. So again, we'll have to continue to watch that and see what happens with that particular agency. But what I'm trying to make here, the distinction for this particular slide is there's the core federal agencies, whether or not federal agencies are hiring H-1B workers themselves, right? And are they replacing U.S. workers? And then there's also the federal contractors. So they are contractors that do business with these federal agencies. And that's very broad, right? Who is that federal contractor? It could be, we have tech companies that, sorry, I hear a lot of ruffling there. There are many tech companies that are doing business with the federal government. And we know that those tech companies are hiring H-1B workers because there's a shortage in the STEM area. And in order to function, in order to be globally competitive, we have to be able to continue to be able to hire those workers. So in terms of, some of the questions we've been getting in the past couple of weeks since it's come out is it going to affect me? We have a federal contract, right? We have a federal contract. Is it going to affect me? And again, as I said, we'll have to wait to see whether or not there'll be a threshold in the contract, a minimum amount, whether or not there'll be exemptions depending upon what you sell to the government or what type of services you offer. So we'll see. In terms of the specific.
So this particular executive order, unlike the others, doesn't immediately impose any sort of new restrictions, impediments. Some of the recent ones we've seen bar visas being issued, bar entry into the U.S., but this isn't about that. This is more about getting information and then taking action. So there's two timelines here, right, Dawn? There's the 120-day and the 45-day. So what does the 120-day timeline really talk about?
Yeah, and the 120-day is really what we're calling Section 2 of the order. The first timeline is, again, no immediate action, but basically it's asking, the federal government is asking its own agencies to go back and to take a look at how often they have used the foreign workers. And by the way, it's limited to the fiscal year 18 and 19. It's focused on those contracts. So it's not like go back to the beginning of time. It's not even go back and tell us what's going on now. It's a very specific timeline in there. And they've asked for, excuse me, they've asked the extent of what's been used and then what is the effect on both national security as well as U.S. worker opportunities. And as we said before, it's also talking about procurement efficiency and things like that. At the end of the 120 days, which by the way takes us after the election, right? It takes us into December. The agencies are going to have to propose corrective actions. Now here, I think it's interesting to kind of call out a couple of things. There's no guidance on the specifics of how an agency is supposed to ascertain these things. So one of the questions that, I have when I read it is, well, where are they going to collect these statistics from? And are we going to be comparing apples to apples or orange to oranges, right? Like, do we know what DHS is going to do versus what TVA is going to do? And then once we get the statistics, are they going to apply the same standard across the board in terms of what the effect is? What one agency or even one person may think may be different. So this is something that we definitely want to keep an eye on. And, who knows, maybe the subject of litigation at some point in the future. But it is important to take a look at that. The other thing that I want to point out here is it's not just the contractors, but it's also the subcontractors. So within those 180 days, they want to know, what was the nature of the work, what were they doing, and again, what's the effect? So when we talk about national security, again, it would be nice if there was some internal guidance to know, are they talking about the types of contracts? I mean, there's already things in place if that's the case, right? Maybe some contracts are limited to U.S. citizens. On the next,
there's another interesting component I found, the fact that they're focusing on 2018 to 2019, but they cite the economic dislocation taking place now. So if we're looking at, that's the basis for taking these actions now, why are we looking at 2018 and 2019 and we're not looking at 2020? That to me doesn't really seem to coincide with their basis and their purpose, which I think will help any sort of litigation as well in the future.
Yeah, and initially, it's funny you should say that. Initially, I thought, I had a reaction that was a little negative, but then I thought, well, if we're looking at current, maybe they carved out current just because of COVID, and maybe they were worried that in and of itself would be a basis for a challenge, and so they wanted, criteria before. I don't know. I'm not sure.
So the 120 days takes us to December 1, which, depending on the results of the election, could mean a lot of things. One could be that this really will be a non-issue. But the 45 days, it's more immediate. And now we're actually closer. We've lost, we're into the 30-some days left. And September 17th would be the deadline. What does the 45 days really target?
Yeah, so when we're talking about the 45 days, they are asking for the agencies to take action, right? They're asking for action to, and I'm going to quote, to protect the United States workers from any adverse effects on wages and working conditions caused by the employment of the H-1B workers at all job sites. They're not only worried about the primary job sites, but they're worried about the additional job sites, third-party job sites, where H-1B workers are placed.
And this does not restrict itself to federal contractors. This is a more overarching, applicable to all H-1B employers. And if I may, we titled this program window dressing or Trojan horse. And this is perhaps the Trojan horse element because of its broader application. We've seen a history of executive orders from the Trump administration, starting with Buy American, Hire American, that turned out to be inducements that behind the scenes led to draconian measures being adopted. And we'll talk about what we think those are, but the reference in the new executive order to Section 212N1 is sort of a laundry list obligation under the labor protections of the Department of Labor's H-1B regulations, which are jointly enforced by DOL and USCIS. And there are some constraints as to what can be done in a 45-day period. So we'll cover that as we go on.
Yeah, absolutely. So I think it is important, the first thing you want to do is ask, well, what is Section 212N1 of the INA, right? So if you pull it out, basically it's the labor condition application. And what it is something that in order to file an H-1B petition, and this may be very, very elementary for some of you, but for others, perhaps not, before you can file an H-1B application with the Department of Homeland Security, with USCIS, you have to have a labor condition application filed with the Department of Labor. So this is a section that mandates that you file it. Section 212N also has another prong, and basically it ensures that the Secretary has a process to ensure that, what happens when somebody doesn't meet the particulars of what they're attesting to in the labor condition application, or what happens when they lie, when they make a misrepresentation. So those are the two important prongs of 212N1. Now, again, I think even for those of you that are signing LCAs on a daily basis, sometimes it becomes so automated, right? I think it's a good time to kind of dust off the LCA and take a look behind it and, see what the attestations are. So, the first thing is that when we're hiring U.S. H-1B workers, we want to, again, ensure that we're protecting U.S. workers. So there has to be an attestation regarding the wage, that U.S. companies are actually paying the higher of the actual versus the prevailing wage to ensure that no similarly situated U.S. workers are affected. We also have to make sure, of course, there's a nod to the unions that there's no strike or lockouts. If there is a collective bargaining representative, if it is a union contract, then you have to make sure that they've been provided notice. And if not, then we just have the regular posting requirements. We have to post in certain places, in 2 places. The Labor Act, the LCA application also has to talk about the number of workers. And then there's also some provisions which we're not going to get into that affect H-1B dependent workers and dependent companies. Those are companies that have a very high ratio of H-1B workers to U.S. workers. And then, go ahead.
Sorry, so there's a lot there, but there's very limited time. So whether or not there's actually anything to come out of this logistically and practically is probably very limited, right? It will likely be more about information gathering. It might be more about more on-site visits, which means, be aware of who's on your site and be aware of where your public access files are for your H-1B. And if you don't know what, then reach out to counsel, call us. But those are the types of things that you need to be paying attention to. But this also isn't necessarily something new, right? There's a history of arrangements among the agencies to share information. So let's talk really a little bit about how we've kind of moved through time in terms of what we've seen with information sharing amongst agencies. Dawn and Angelo, I'm going to turn that over to you guys.
Well, let me begin by saying there's a certain deja vu element here because we have seen actions surface from time to time as far back as President Clinton, and we'll go into some greater detail as to how that began. But most recently, what we have seen in the previous administration, the Obama administration, was the formation of an interagency working group for the consistent enforcement of federal labor, employment, and immigration laws. And that was trumpeted with a great deal of fanfare, but it didn't do much, at least publicly. If you search on that phrase, interagency working group, you're not going to find a great deal of material other than the NLRB has a few links that don't say very much. And so whether the Trump administration can try and revivify in the waning days of its own period of control a campaign that never got off the ground in the first place is a very much open question.
Yeah, absolutely.
But we can go back and talk about the fact that still today, virtually all of the bureaucracies that have a role to play in immigration have entered into memoranda of agreement or memoranda of understanding that deals with collaboration, information sharing, and the forwarding of complaints that come to one agency that falls within the bailiwick of another agency. That's been in place all along, and that has led to some pretty serious investigations of unfortunate employers who've fallen under that microscope. What we have also seen was an effort in February of 2018 where USCIS began to mandate that employers placing workers at third-party sites provide a great deal of information that it was under the so-called itinerary requirement and also under the purported obligation to determine whether the work to be performed at the third-party site met the definition of an H-1B specialty occupation. Well, recent litigation, and we have published on that on our blog under the big immigration blog. If you search under the phrase litigation victory, you'll find the IT tech serve decision mentioned, but most importantly, a USCIS memo that rescinds any obligation to disclose third-party site information. And so if it's not required and if the agency's adjudicators don't have the authority to request that information, the simple recommendation to employers is don't provide it. And then, Dawn, maybe you want to talk about the new LCA requirements of November 2018.
Yeah, and I think, you know, even before we get to that, let's talk about administrative site visits, right? We do think that there will be an increase of site visits, but we're in the middle still of a pandemic, right? So what's happening? Well, first of all, I can tell you we do know that site visits are taking place because we've heard from companies that they have been visited. Or that there have been phone calls made on certain things. So I see some of you are asking about site visits being conducted when the site is closed to the public. So I would assume that the agent or the contractor that's coming out to visit will make some sort of arrangements in order to come on site, or maybe just to get additional information. And we'll have to see, because I think this is going to be fluid as the state of the country, you know, changes. I think it's also going to make a difference in what location you're in. I mean, frankly speaking, we know that certain government offices are not back to work. I mean, the Immigration and Customs Enforcement, you know, agents are working from home, you know, for the most part right now. So I think it's important to make sure, as Masa said, that your public access files are up to par. In terms of inspections, I think that there could be ways for DOL to ask for you to send an online copy or to ask for a visual, you know, a video meeting. I think there's lots of ways. Now, if your site is totally closed down, that's a different story, right? So
well, let me jump in there for a second. When we talk about administrative site visits, we're really talking about a unit of the USCIS called Fraud Detection and National Security, and it's really an open question as to how much they can do in the short term, because the agency is facing at the end of this month a 70% reduction in staff with a furlough for budget shortfalls and many would say, including myself, agency mismanagement of resources. So what has happened recently is that FDNS has reached out to employees, sometimes unbeknownst to the employer. The H-1B worker will get a request to meet at a USCIS office that has partially reopened, or just to meet at a third-party location and be interviewed. And so be aware that that is a technique that can be done, and also be aware, as I've written extensively, that the entire unit, the Fraud Detection and National Security Unit, is very likely a violation of the enabling legislation, the Homeland Security Act that created it, which
all right,
I'm going to just finish my thought, because if you get knocked on the door by FDNS and you want an affirmative defense, you just say they're illegally constituted, because USCIS is supposed to be a benefits agency and not an investigation police unit. And so employers need to know that.
True.
Well, important to have protocols in place, definitely. So going back to the LCA requirements, sorry.
Just jumping in quickly, Dawn, as you said, you know, all of this is really evolving. We don't quite know how this is going to take shape, but we may be able to look to how OFCCP is still conducting its on-site investigations. Currently, they're doing everything virtually. So they will interview employees, they will interview management, they will review documents. It will all be done virtually. So that may portend for for how USCIS might go about enforcing on their side as well.
And I agree. We're seeing that with the Department of Justice. We have IR investigations that are continuing, and we've done virtual meetings whereby, in the past, maybe they would have interviewed witnesses or, done something in person. So I absolutely agree. The other thing I want to throw out there is I've heard from our colleagues in our employment group that the wage and hour investigators that they've been hiring and increasing. So we don't know what's going to happen. Once things quiet down, will there be an increase of these unlawful fraud detection unit people? Will we see more FE&S investigators hired, and will they be working with DOL, right? Because as Angela mentioned, we do have a long history of memorandum of agreements and MOUs between the agencies. And so it is something to definitely keep an eye on. And again, I mean, myself, I dusted off. I was looking at like what DOJ, what they have in place, what USCIS has in place, and kind of I mapped it out to say, okay, well, they can share this, they can share this. And then there's also the task forces where they share information amongst themselves or they collate information. So I think in the past, we haven't really seen the fruits of that. Again, depending upon what happens in November, there may be more interagency, more successful interagency cooperation, but I'm not sure. So in terms of the changes for the LCA, I think the biggest thing that we have to keep in mind there is just the fact that secondary employment sites, where if an employer was placing an employee somewhere else, those sites had to be disclosed on the LCA. The other big thing I want to point out is that the Department of Labor is releasing all the information. So for the first time in the past few years, we've seen like who are the big users of H-1Bs, and then are the sites actually listed. So I think there was some talk about that TVA, about the Tennessee Valley Authority, whether or not H-1Bs that were actually on their sites, whether or not they had LCAs in place to actually be there. So if you're moving people, talk with your counsel and make sure, determine whether or not you need to have another LCA done at the site. So in terms of the executive orders, Angela, that you mentioned, and as much as some people want to blame this administration, actually the original executive order, which was 12989, was pushed out by the Clinton administration. So give us some direction there.
Well, it's interesting because that regulation expressly affected federal contractors, and it purported to relate only to the employment verification eligibility requirements and the I-9 and the duty to refrain from employing someone whom the employer knows lacks the right to work. Well, how could this come up in relation to the new executive order that the Trump administration has just issued? It's relating to a concept of guilty or culpable knowledge. If a federal contractor has knowledge that a sub has in fact unauthorized workers in its employ, and that prime contractor continues to engage with the sub and continues to avail itself of the services of that employee, that could be a violation of the prohibition against knowing unauthorized employment. And as a result, that could lead to an order of suspension and debarment under Executive Order 12989. No one that is in the federal contracting business wants to be suspended or debarred because it bans contractor participation either temporarily or for a period of years in federal contracting, and participation in all sorts of other federal programs such as loan guarantees, drilling rights. A whole host of federal programs would be debarred. It also causes the federal contractor's name to be published on a list of prohibited parties. In other words, your customers, even though they're not federal contractors, they're private customers, would be barred from engaging in transactions with you. So that's where all the teeth would lie in this, is this prohibition of knowing unauthorized employment. And bear in mind that EO 12989 was expanded to extend to E-Verify under the Bush administration, and therefore it is not merely the paper or electronic I-9 that is the issue, it's also what knowledge may come through E-Verify mandatory enrollment of certain federal contractors.
Yeah, and let's take 1 minute to talk about that. President Bush did amend Executive Order 12989, and what he did was basically tell federal contractors, if you want to do business with the federal government, you're going to enroll in the E-Verify program. And E-Verify is the electronic review of the work authorization of individual employees. So basically, you take your I-9 information and then you run it through this government online internet program. It was a huge boost for E-Verify when this was rolled out, because not only did it require federal contractors, but there was actually that slowdown that we've been talking about. So if you're a federal contractor, you had to enroll in E-Verify, and then you also had to flow it down and have your subcontractors enroll. So, you know, we're watching to see. Now, again, we talked about not all contracts were included. There were some exemptions, including if you sold the government commercially off-the-shelf goods. So there's all different types of things that we need to take a look at. But I did want to, again, you know, show that there's this history here. So in Martha, I think we can go to the next slide. Thank you. So here, in terms of the agreements, the latest one that I want to talk about is a memorandum of agreement between the Department of Labor and the Department of Homeland Security. Now, first of all, I want to put out there that we have not seen it. I didn't check this morning, but we've, as of yesterday, it still has not been published, which is interesting. There's a press release that's up. It was signed on the 31st, and it tells, you know, what the government's going to do. But usually there's a little PDF. I actually wrote to the person responsible. I haven't heard back. I said, hey, can we get a copy of it? Called all my contacts. Has anybody seen it? Still don't have a copy of that. So I think it's important to make sure that we see what's going to happen with that.
I think we need to move back to the previous slide. Yes.
Yes, sorry about that.
What's going to happen with that, because it is important. So in the news release, basically, it's an information sharing agreement. And what it says is that the Department of Labor and USCIS, right, so it's DHS, but it's the USCIS, they're going to share information about all types of petitions, non-immigrant and immigrant petitions, and the data that's in there. Again, there's a lot of information in the labor condition application databases. It also establishes processes, and I'm reading, by which the USCIS will refer suspected employer violations within the H-1B program to the DOL that USCIS identifies in the course of adjudicating petitions. And we all know, for those of you that are in the visa business, USCIS has really been adjudicating and taking a look at these petitions like they've never looked at before. So the data that's in them, they're able to use it and then to refer information. Obviously, they're focused on H-1B compliance.
And Dawn, if I could point out something that might not be readily apparent, since the information sharing will involve the Office of Foreign Labor Certification, and that office has jurisdiction over both the temporary categories, the H-1B and the H-2 categories, but it also has jurisdiction over the permanent and temporary labor certification categories, and there the risk is that what DOL will provide in abundance to the USCIS will lead to more requests for evidence, more notices of intent to deny, because USCIS adjudicators look for the slightest discrepancy in information between what is submitted on the employer petition and what has been told to the DOL. So those kinds of inconsistencies, if they exist, and can't be readily explained could lead to denials of requests for immigration benefits and could lead to revocation of approved petitions, which would be devastating to the continuing employment of existing workers.
Yeah, there is a whole host of the parade of horribles there. And again, we don't know the extent that they're going to data mine. We don't know the extent that they're going to share. I'm very interested in seeing the underlying actual agreement here. But we know that this administration has focused on transparency. The information that DOL has been able to push out, to collect and then be able to push out, really has been incredible. And so if you're in the business of being able to crunch that data and take a look at it, it could be used in a whole host of different ways. So I think it's important that the individuals that are filing these petitions know what type of enforcement is going to be coming down the pike. So we invited Mike to actually participate in this, because when we were reading this, one of the first things that came to mind is, okay, well, what else can happen, right? So right away I look at it, it's like, okay, and by the way, we have a full group, including Larry Barber, who's a prior official over at the DOL that focuses on this. So for OFCCP compliance, Mike, tell us, like, should I be worried? Should I not be worried? What's going on there?
Yeah, so it might seem kind of out of left field to be talking about a civil rights enforcement agency within kind of the immigration compliance space, but it's actually got some kind of historical precedent to it. So the OFCCP has incredibly broad investigation powers, despite the fact that it might have fairly limited enforcement powers. And so there are a couple of things about the OFCCP that might make it uniquely well suited to be a way into contractor facilities to begin these kind of investigations. So first and foremost, OFCCP enforces affirmative action, equal opportunity, and non-discrimination laws using collection of data and on-site compliance evaluations that are randomly selected. These are not necessarily in response to any kind of complaint or charge being filed against the employer. OFCCP randomly selects somewhere between 2,000 and 3,500 facilities to randomly audit every fiscal year. So at that point, we've got a pretty wide pool of people that might not otherwise find themselves involved in a government investigation. Secondly, OFCCP in the past has had memoranda of understanding with agencies like ICE to investigate and to review, as part of their on-site review of documentation, I-9, and where they have found that either the I-9s couldn't be produced or the I-9s were, I don't even want to say deficient, because I don't know if OFCCP compliance officers are necessarily trained to identify a deficient versus a non-deficient I-9. I don't know that I necessarily have all of the expertise to do that, but they certainly have the power to say, we think that maybe this would involve a closer look, and refer those situations out to ICE. OFCCP stopped doing this via an official directive in 2010, but prior to that, they were actually doing this as part of on-site investigations, and you had to prepare for those. And just kind of as a footnote on that, OFCCP on-site investigations might not sound that intense, but OFCCP compliance evaluations can last for years upon years, even before you get to an on-site investigation, and can end up costing you hundreds of thousands, if not millions of dollars, not just in attorney's fees, but in back pay, conciliation, any number of other remedies that are available under the statute. So these are not things to be taken lightly. Similarly, OFCCP jointly enforces labor relations violations that they find as part of on-site investigations, and they'll both jointly enforce those and refer violations out to the Office for Labor Management Standards within DOL. They have a similar referral situation with violations of the Service Contract and Davis-Bacon Act. for wage determinations that are deviating from those, and they'll refer those out to the wage and hour division within DOL for further investigation. So they can start asking a lot of questions and requesting a lot of documentation, even if the agency itself doesn't have the authority to bring enforcement actions under those. And I think that's one of the things that we might want to keep our eyes out for as to whether or not the memorandum of understanding or subsequent regulations empower the OFCCP to refer any violations that it finds of LCAs over to USCIS.
And that's important.
Perfect. Yeah, that's important, but a perfect segue to our next kind of thought on DOL's power to investigate. And really, Angelo, you have a lot to say about this.
Well, because there's a long statutory tussle that occurred when a section of the Immigration and Nationality Act was enacted many decades ago, involving what would be the authority of DOL to investigate a labor condition application violation under the H-1B rules. And it was decided that the whole concept of an LCA, a labor condition application, would be a basic attestation process where aggrieved parties would be obliged, if they wanted to complain, that the DOL would not have independent, self-generating authority to investigate, unlike the OFCCP, unlike the Department of Justice's Immigrant and Employee Rights section. The Department of Labor, because of this negotiated statute, has no easy authority. Anytime they want to investigate something that is not based on a complaint from an aggrieved party, the DOL secretary has a non-delegable duty personally to certify that reasonable cause exists to investigate. And its reasonable cause must be based on something heavy duty, a serious, willful, substantive, or pattern or practice violation of the H-1B LCA rules. Probably not an inadvertent failure to post at a job site a notice of the promises in the labor condition application. And the statute also says that the DOL secretary, in determining reasonable cause, cannot consider the information the employer submits to USCIS in the H-1B petition. And since it cannot be an aggrieved party itself, it can only use that extraordinary certification authority of the DOL secretary. There is a provision that may allow in the regulations of DOL an end run around that, because an aggrieved party is not only an individual who might have been shortchanged on the prevailing wage, but it's a government agency which has a program that is impacted by the employer's alleged non-compliance with the labor condition application. And in the rulemaking history, they point to a consular officer of the Department of State might conceivably be an aggrieved party. So how could this play out? It could play out if the OFCCP, or as we mentioned, my favorite unit within USCIS, the FD&S unit, might try and develop information outside the four corners of the H-1B petition and feed that back. And if it was an egregious violation, then perhaps the DOL secretary might personally certify. So it's an easy prediction. Expect more OFCCP investigations and more FD&S site visits.
Yeah, and
to piggyback on...
Michael,
to
go
piggyback
ahead.
on what Angelo was saying in terms of how OFCCP might go about kind of cultivating or investigating this, as part of OFCCP compliance evaluations, you have to turn over a lot of compensation information. And they will run statistical analyses on this compensation information and spot variances within your compensation structure. So if you have varying compensation because you're not, for example, paying a prevailing wage that you're required to, that could be the kind of entry that you need to start asking further questions that might lead to a referral.
And that's an interesting point, Michael, because when you look at the H-1B regulations, there is a definition of the required wage that the employer must pay, and that is the higher of two measurements, either the local prevailing wage in the geographic area of the work site, which is publicly reported in most instances on the DOL website and elsewhere, but also the actual wage paid to similarly situated and qualified U.S. workers, and the employer can apply objective factors to create its own pay system. And these objective factors are quite flexible in how they can be defined, so that a statistical review by OFCCP might find what appears to be a discrepancy that the employer can explain on an employee-by-employee compensation decision basis. That's a daunting investigation to have to defend. And by the way, the party against which you would be faced would be the Wage and Hour Division, which also has other investigative authorities under the DOL statutes. And so this is, I would say, not window dressing when you put this all together. It's the nose under the camel's tent. And frankly, even the outcome of the election might not change the inducement to have these agencies cooperate to a greater degree and initiate investigations.
That's a big one there. Once the collaboration starts, you don't pull it back, right? We haven't seen anything pulled back to a great extent from previous administrations. Sorry, Don, you had a comment?
I would just say, look at Netflix's Immigration Nation, where they originally, under the Obama administration, targeted serious criminal violators for removal, but then they came across people who just happened to be undocumented, and they were called collaterals. Well, once the eye was open and the collaterals were identified, then the enforcement goes forward full force without regard to the original mandate.
That's right. And we have investigations that were started under the Obama administration that are still in play today, and the Department of Labor, or Department of Justice has, not let up on those. So I just want to, with Angela, with what you were just talking about, I want to tie it back to the MOA, because I think it was intentional. I think that this is, I don't want to be in this conspiracy theory mode, but I do think that the processes that are established between the USCIS to refer these suspected employer violations, to the DOL, I think it's important, right? So they're telling us they're going to be looking at the administrative and the targeted site visits. But the biggest thing in that MOA that, again, we're waiting to see is what we saw in the press release, where they discuss the president's personal power to initiate investigations of potential violations. And they talk about how it's unique. And
you mean the secretary's personal power? The secretary,
yes, the secretary's personal power, yes. And so within that, we're going to have to see how is that going to play out, because the press release has said no prior Secretary of Labor has ever exercised this authority, right? So what's going to happen when Secretary Scalia decides if he might to use his power, and in what timeline is it going to be used? So we really are going to have to take a very close look and keep a close eye on what data is being exchanged and what they're going to be doing with it.
And I think when we look at this, just to comment briefly, of the two, the new executive order and the memorandum of agreement for information sharing, I would say the latter has the likely longer lifespan, even if after the election we have a President Biden coming in and appointing Alexandria Ocasio-Cortez as a Secretary of Labor.
What a different world would that be? And that takes us into even longer term implications, potential regulations, right, that this administration might push forward, seeing the president's, one of his latest comments on regulations being in progress to help protect U.S. workers against the use of H-1Bs. So, you know, we have the potential of what? Interim regulations. We have the potential of regulations that go through notice and comment. We have the potential of midnight regulations that we've seen prior administrations use. Angela, what do you think of that and the possibility of that taking place between now and January?
Well, you have to be a student of the Administrative Procedure Act and the Congressional Review Act to really understand the nuance there. But essentially, the Administrative Procedure Act creates very few exceptions to the notice and comment right of the public to review agency action that will change policy before it happens. And rarely is a rule allowed to go into effect with immediate effect under what is called an interim final rule. Usually there's going to be a 30-day minimum advance opportunity to comment. Once the comment is in, the Office of Management and Budget must circulate the rule and all the comments, not only to the affected agency that drafted the new regulation or proposed regulation, but also to all of the other federal administrative agencies that may have jurisdictional authority that touches on it or an interest in the subject matter. And as a result, it often happens that these are midnight regulations. We saw some 2017 midnight regulations of the Obama administration, the entrepreneur rule, parole rule, and the skilled worker rule. And what happens is that there is something called the Congressional Review Act that lets an incoming Congress overturn a regulation within a set number of days and preclude the agency from engaging in rulemaking on the subject. So it's anyone's guess what's going to happen in the meantime. But in terms of this particular slide, can DOL or USCIS take action under INA Section 212N1 now? They sure can. Nothing to prevent that. Whether there can be a legitimate complaint of an aggrieved party that DOL's Wage and Hour Division can pursue, that's entirely another question. But they can start one now. My experience, they wouldn't finish it before the election, or certainly before the turnover of power, if that's what occurs.
And I think what we've highlighted is during this really limited time, September 17th is coming up really quickly. We're not expecting to see big changes or in regulations or law, but what we are expecting is some of those more on-site visits and investigations to start taking place. So you might see more of that happening. What does this mean for companies and contractors? You know, we've noted this is a crystal ball time because really it is. There's so many factors here and variables that could change this drastically. One of the most important ones being the election and the outcome of that. John, tell us kind of your thoughts on some of what we might see.
Yeah, I think with the timelines, as we just talked about, it's going to be difficult. I mean, they're having difficulty in pushing other regs through, so it's going to be difficult to push anything new through. But there is enough existing things that are already on the books that can, you know, create some agita for employers. So I think it's going to be, you know, we're going to have to keep an eye on what's going to happen on those attestations that are already in place. Like, are they going to, is there going to be any more investigations or enforcement, like maybe cases that will be low-hanging fruit that they want to make examples out of? You know, we don't know what the DOL already has, you know, in their, you know, in their toolbox. What are they already investigating? So that'll be interesting to see whether or not they're looking at the third-party staffing and in terms of the attestations. I mean, Masa, just really, I'll turn it to you before I want to talk about the foreign, specifically about IAR. But is there anything here that you think we're going to see on the day-to-day attestations that you work with companies on?
Yeah, I mean, I think this third-party work sites with your end, you know, if you're an end client or you're contract and placing workers on end client sites, I mean, that's been something that's been an issue that we've been grappling with since the LCAs were updated, requiring including the work sites and the names of the end clients, right? So that brought up a lot of questions, a lot of concerns, including, you know, are these additional indicia of joint employer liability? If we're going to continue down this road, what does that mean in terms of the end client having more information and knowledge about the people being placed on their work sites? It also talks to, do you even know if you have H-1B workers on your site, and how are you kind of, what protocols do you have in place? So all of those things I think will probably be highlighted even more, and it will be more important for end clients to take a closer look at how you know, these staffing agencies or consulting firms or whoever you have on your site are selecting their workers and placing on there, and then what precautions have you put into place as an organization in terms of your agreements with your vendors when they're placing workers. So those are all things that will become really important. I think even beyond this administration, because this started before this administration, I think it'll continue, especially with an economic downturn where the market conditions with the job unemployment rates really do end up having the Department of Labor get more involved and more targeted in the use of both the temporary visa programs, but also the permanent visa programs for sponsorships for green cards.
I agree with you. And let's talk a little bit about the Department of Justice, about the Immigrant Employee Rights Division. So similar to what Mike was talking about on the OFCCP side, there is this broad authority for them to conduct investigations, right? And they were charged under this administration after the Baja order went into place. There was interesting, you know, there was an initiative, the U.S. Protecting U.S. Workers Initiative that came out. And so IAR is doing a lot of investigations into whether or not there is a increase of issues between U.S. worker jobs being taken by foreign individuals. But the thing that we have to know about IAR is they may get a complaint, a specific complaint about a specific case, about a specific worker. They have a huge, broad authority then to kind of pick up and look under the hood. So they may be talking about Angelo. That's where Angelo's complaint may have come in.
Keep me out of this. Keep me out of this.
Well, you know, you're a lightning rod, so.
That's why I don't want to be investigated. So.
Exactly. So, at this point, it's important to remember to take those complaints and to get, any concerns with IAR very seriously, because I do think that not only under this administration, but under the next, whoever it is, that those initiatives will still be focused on, because there's been a lot of time and effort, put into that. So there's that, and then again, like, what are they going to do with this FAR regulation? We're going to have to watch it. It's we have the crystal ball, and I usually like to really dig into the crystal ball, but there's just so much uncertainty here. I think it's just important to do practical things right now, right? So like Masa said, we want to look at the labor condition applications. Sometimes we become too remote, right? Oftentimes, Masa and I, we're constantly looking at other filings that were done by other firms or other companies when, we're transitioning things into us. And we're looking at it and saying, where did this come from, right? Was there a basis for this? So there has to be a little bit less automation and a little bit more care being put into these things. If you're signing your name on something, you really need to know what you're signing under, and you need to check the accuracy. Whether it's an extension or something new, spend the time up front on that. I can't stress it enough. And then a big thing that I spend a lot of time on are master services agreement and staffing agreements. So I spend time on it in the I-9 realm, right, to make sure that any vendors or suppliers or staffing agents that our clients are dealing with, and I do it on both sides, that they have the right language in there to ensure that we have workers that are able to work in the United States. But there is another component that also we work on, which is the information on the foreign workers. So here we have to be really, careful. We have to decide, how much information do we want to know about the foreign workers? Right now, we don't really want to know a lot, but what we want the MSA to say, what we want these agreements to say is, if you're using workers, okay, number one, we should know that you're using workers. We don't want to know the specifics. We don't want to know all the details, but we want to know if you're using those workers. And we most importantly want to make sure that whatever you're doing is compliant. So we want to have an attestation in there. We want a rec, and we want a warranty, and we want an indemnification that if you're doing something incorrectly, we're indemnified. We want to limit any joint employer liability, right? So we want to make sure that these agreements are crafted in such a way that there's supervision by the part of the actual employer, and we want to make sure that they're paying the right pay and that whatever they've put in their attestations to the government, that they're actually doing it. Now,
well, we don't want to know specifics, right? We want to be very careful with what we're asking for, because those are the additional factors that are going to be problematic when Labor and Employment Council comes in and says, look, it looks like a duck, it walks like a duck, then it's a duck, right? So we got to be really careful with that. And we also want to make sure that we're paying attention to not just our direct vendor, right? Sometimes it's the placement of workers through their vendors or their vendor's vendors, so they're second or three times removed. And it is in the terms of your agreement with your vendor that you want to make sure that you're careful in ensuring that they're taking all the steps they need to, regardless of how they're sourcing their workers that are being placed on your projects. One of the biggest things is all of a sudden learning that you have H-1B workers on site because you have an FDNS on site visit, right? Not because you and an LCA posting took place, right? Not because your vendor told you that they're putting H-1B workers, but because you have a FDNS officer, whether legitimate or not, Angelo, showing up at your doorstep to talk and ask about this individual being placed, or more frequent these days, it's been before the memo rescission. It's been a request for you as an end client to write this long letter attesting to the work that's going to be done by this H-1B worker that you didn't even know existed, and their credentials and what duties they have and what salary they have. Well, you're not the employer, so all of those are factors that you have to be careful with.
Well, Masa, you mentioned looks like a duck, walks like a duck. But I hear in-house counsel tell me, don't give me that quackery. I want you to tell me what we can do, because we're worried about our brand, and we don't want the brand damage of adverse press to come out, even if we're completely innocent of knowledge. And what I recommend in that context is that they require the other side of the contract to engage the services of a third-party immigration audit firm, whether it's a law firm or a non-legal firm that might not have the attorney-client privilege to protect the investigation, but nevertheless, that third party would certify to you that the contracting sub is in compliance with the immigration law. They even sometimes go to a badging proposition where no one can get access to the physical premises unless they have a badge, and they can't get a badge unless the third-party auditor has given them a clean bill of health from an immigration compliance perspective. So I think there are some things to do, but constructive knowledge is a powerful force, because you get blamed for what you should have known and not what you actually knew. And you want to avoid that in the immigration context.
Yeah, and those third-party audits can be written in, but you need to think about them. And I use them all the time, especially on the I-9 side. But again, you have to be able to flow it through, right? When you're writing out the contract. So what happens if the auditor comes back and says X, Y, and Z? So it's definitely something that I recommend exploring, but understand before you actually implement it. So I do
a lot of nuance there.
We have a few questions. I'm wondering if.
Sorry, Angela. Before we go to the questions, really quickly, let me share the CLE code with everyone. It's SS Seyfarth Shaw 2279. Again, that's SS Seyfarth Shaw 2279.
And Michael, there seems to be a question right up your alley. Does the OFCCP have the budget and staffing to handle these incremental investigations?
So I don't think these would necessarily even be new investigations. I think they might be kind of a new step in the current investigations. And in terms of budgeting and staffing, OFCCP is kind of putting forward more expansive audit and compliance evaluation lists each year. So they started off with a broader list this past fiscal year than they had previously. and then dumped on additional focus reviews on top of that. So I don't think we have any reason to believe that they're necessarily going to slow down or cut back on the number of investigations they're doing. I think they're just going to try and be more conscientious, and they've released several directives to this effect, more efficient about the way that they're conducting these investigations.
Well, that's interesting because that's leveraging the employer, or I should say the contracting party's obligation to come forth with information about third parties. And when we were engaged in planning this panel, we talked about what authority would the OFCCP have to force an employer to go and insist that a subcontractor provide detailed information. Does it exist?
So there is kind of limited circumstances under which prime contractors do have obligations to inform OFCCP about bad actions by third parties. They're very similar to, I think, what you referenced, the constructive knowledge obligation in the immigration space. So if a prime contractor acquires knowledge or has reason to believe that a sub or a union or a vendor is engaging in violations of the obligations that the prime has flowed down to that third party, they have an obligation to inform the OFCCP. But outside of that, you have an obligation to flow down and make your subs aware of their affirmative action, non-discrimination, EEO obligations, but you don't have the obligation to show up on their site, stand over them, and make sure that they're doing everything that they are attesting they're doing.
And talking about the budget question, DOL as a whole doesn't have the budget to enforce the immigration laws because, unlike USCIS, there's no user fee associated with any of the services DOL provides in terms of a prevailing wage, in terms of the attestation on a labor condition application.
Don't give them any ideas.
That's what I was just
Well, it's not me. It's already in the Fairness for High-Skilled Immigrant Act that is almost by a hair's breadth had passed the Senate last week, except for our senator from Florida who prevented that from happening on unanimous consent. But there are provisions that would accord appropriations to the DOL for these kinds of investigations, and so the problem exists that there just simply is likely to be a trend toward leveraging what they can elicit from the employer who is the subject of the investigation to help them do their work more efficiently. There were some other questions that dealt with site visits and public access folder access. Those are very good questions. It said, how would on-site visits be conducted when our site is closed to the public? Well, they just changed the site to another location. And as I said, it might be the USCIS office if a local office is open, or it might be, a parking lot at the local Chili's. But they're using their authority to investigate, their purported authority, but they're not necessarily restricted to making in-person visits. As for how do you comply with the public access obligation if the site is closed? Well, you really can't. If your office is closed because of health orders from a governmental authority, I think that's going to be a defense. And there's no obligation to send anyone a copy of the public access folder. There's a case that doesn't even say you have to provide a paper copy when someone comes in. All that you can do is allow them to review it and presumably take notes and maybe surreptitiously do a smartphone photograph of what the public access folder says. But it's not as public as the word entails or suggests.
Yeah, there's a lot there, and just being aware of everybody's time. And thank you for joining us. We're a minute past due. I'm going to repeat the code one more time for everybody. SS Seyfarth Shaw 2279. SS Seyfarth Shaw 2279. Thank you all for joining. We really appreciate your time today. Be on the lookout for our next pop-up, which is next week, focusing on the travel restrictions, bans, visa bans, and then the exemption requirements that have now recently been published. Thank you, everyone.
Thank you.
This concludes today's webinar. Thank you for attending.